Okay, we're going to begin. We are on equal protection, and we discussed Brown versus Board of Education, where the petitioners had faced and overcame the difficulty of proving that a racially neutral state action, which is mere separation of two races, actually does constitute discrimination against one of the segregated races. In doing so, the court engaged in a very in-depth analysis of the facts, unlike in Beezer. If you remember, in Beezer, the evidence that at least there was 1/3 of methadone users who could be employable as non-methadone users, that evidence was ignored by the Supreme Court, if you remember. But in Brown versus Board of Education, the scientific evidence that the children's development was retarded by state-sponsored classification of the children into different races, that evidence was not ignored. That actually became the centerpiece in the court's reasoning. So these two cases show how the standard of review, like how hard you look at a certain classification. All discriminations are premised by classifications first, right? You have to classify people into two different groups, and then you discriminate, right? So when I say classifications, I'm talking about, the advanced stage right before discrimination. So depending on how hard you look at, how hard or how strictly you scrutinize, examine discrimination, sometimes it comes out unconstitutional, other times it does not. That standard of review or level of scrutiny is a very important and determinative of constitutional analysis. So we then looked at another racially neutral classification in Washington versus Davis, where unlike Brown versus Board of Education, where race was explicit criteria in segregation, race was not mentioned at all in the police hiring examination that was given to blacks and whites alike. It was the same examination. Did not use race as criteria at all. When this happens, what do? Do you say, because at least the claim is made on the basis of race, do you use a higher scrutiny like in Brown versus Board of Education, or do you use lesser scrutiny, low-level review like Beezer? What would you do? There is a examination, there is a standard, there is a classification that does not mention race at all. And people are challenging the classification to be discriminatory against certain race. Would you apply high-level review or low-level review? Or if you can increase the level of review just on the basis of the impact, just on the basis of the result, many classifications will be able to challenge at a higher level review. Even Beezer, instead of saying, oh, you know, there's a method and users, this is discrimination against the method and users, if there are many blacks among method and users, they'll be able to make another argument, a different argument, saying, oh, barring method and users causes more negative impact on blacks than whites, so this is a racial discrimination. And by making that argument, petitioners will be able to invoke a higher level of review. Now, you don't want that to happen. You don't want the level of scrutiny to vary, right, to change according to what argument you present, right? So, commonsensically, according to common sense, it seems that this racially neutral exam should not be reviewed under strict scrutiny. And that's the result you got. The Supreme Court says, we read the case, that racially neutral classification will be reviewed under rational basis review. Okay. Now, by now you should wonder, when is something subject to, why is race subject to heightened review, high level of review, when other classifications are not? Why is that? There are several explanations. I'm not going to go into all, but here are some of the more persuasive ones. One is framer's intent. Okay, what do we mean by framers? You have heard the term legislative intent. 입법 목적 얘기하는 거죠. 입법자의 의도. 근데 헌법도 법이니까 입법자가 있을 거 아니에요. 그렇죠? Constitutional law is also law, but if you call it legislative, leg here means really law. Doesn't mean constitutional law, right? So instead of legislative intent, you use the term framer's intent. Because constitution, what does constitution mean? Constitute means form, frame, right? So what was the intent behind the framers of the Constitution? Now there are two different groups of framers. The country came into existence in 1776. So there was one group of framers including George Washington, Thomas Jefferson, Alexander Hamilton. But they died off by the time Equal Protection Clause was passed. Now, I told you that Constitution was adopted together with First through 10th Amendments. It's called amendment, but it's really not, because it was adopted together with the main text. But the ones starting out with the 11th and all, they were adopted later. So they are true amendments. Now, out of them, 13 through 16, especially 16, no, 14th. Fourteenth Amendment this one has Equal Protection Clause. So for 100 years, this was passed 18 something. I forget the year. I'm bad with numbers. So for 100 years, the US Constitution didn't have any equality clause. Okay? Only when 16th Amendment was adopted, then it had, no, 13th to the 16th Amendment was adopted, then the US Constitution had finally an equality clause. Why did they do that? Well, what happened between 1776 and 18, whatever, I think it's 18, I'll look it up later. But what happened between 1776 and adoption of these 4 amendments, including Equality Clause, was the Civil War. The war where northern states fought with the southern states over whether slavery will continue to exist. And slavery was the northern states who wanted to abolish slavery won the war, and they wanted to change the Constitution to reflect the result of the war. That's why it had 14th Amendment. All people are subject to equal protection of law, which means blacks will be subject to equal protection of law. People who were previously under slavery, right? So one explanation of a higher level of review is that, well, the framers of these post-war amendments, okay, post-war, 전후 수정헌법, the post-war amendments was to ban slavery or stop any other similar system that would discriminate against the blacks. So the main purpose of Equal Protection Clause was to ban racial discrimination. That's why we have to look harder at have to look at racial discrimination with a higher requirement. Second explanation is that this is something developed by the Supreme Court itself. The Supreme Court often said immutable trait. Immutable trait means traits that cannot be changed. Discriminating someone on the basis of immutable trait is just unfair. So, being born black, being born woman, right? Why this is unfair? Well, because it's something that you cannot be held responsible for. Now, discriminating someone for method and use, it is less unfair if you think about it, because, well, that you are using methadone means you have chosen to let you fall into drug addiction, at least for a while. Yes, you are trying to get out of it now, but you had the choice not to fall into addiction to begin with. Same thing with discrimination against ex-offenders, 전과자죠. You have chosen to commit a crime. So, but immutable traits that you are born with, it's not something, it will be very unfair to be classified, discriminated on that basis. So there's biological differences are often the subject of strict scrutiny. Now, let's think about, not now, but as we look at other classifications of discriminations, let's think about whether these explanations are persuasive in selecting the level of scrutiny for each discrimination. And we already have a very difficult case right now on page 649. Affirmative action case. Affirmative action is action taken usually by the federal government to undo the effects of past discrimination. So, to give preferential treatment to the formerly discriminated group so that their positions are made more equal to the dominant class than without the affirmative action. So in case of Becky, for years they realized that even after even after the passage of equal protection law or equal protection clause, so many of the discrimination laws and segregation laws, okay. All right, question. So federal constitution was changed. Now there were state laws that were discriminatory against the blacks in place when equal protection clause was passed. What happens to the state laws? I gave you a lecture about it. What happens to the state laws that discriminate against blacks when the federal constitution is changed? What's the relationship between federal law and state law? Can you choose which law that you are governed by? Or are you subject to both laws? Just like if you live in Seoul, you are subject to Seoul City Ordinance and the law of Republic of Korea. Well, if you are subject to both laws, what happens if one law says you have to discriminate, the other law says you cannot? When there's a conflict, federal law is supposed to win, according to what? According to supremacy clause of the Constitution. Okay, so when equal protection clause was passed, all the state laws discriminating against the blacks became void, but that was not apparently enough to stop private parties from discriminating against colored people. So even after Brown versus Board of Education, the public transportation restaurants, they'll have white only areas and colored areas. Bars, hotels. So by 1960s, private segregation continued to exist. Although public segregation was struck down as unconstitutional, as you could see in Brown versus Board of Education, it continued to exist in private sector. So federal government passed a law, Civil Rights Act. And one of the things so Civil Rights Act was basically anti-discrimination law. Do we have a Civil Rights Act in Korea? 차별금지법이 있나요? We don't. The only one we have is, actually you can say two, is one is 장애인 차별금지법, okay. Anti-discrimination law to protect the disabled, and also anti-discrimination law for women, but only in conditions of employment. Okay. So two narrow laws, but Civil Rights Act of the United States was comprehensive anti-discrimination law. Now, together with Civil Rights Act was affirmative action What is affirmative action? Well, Civil Rights Act says you shall not discriminate, right? You shall not discriminate. So, shall not, this is negative, telling people not to discriminate, right? Affirmative action is affirmative. Instead of saying you shall not discriminate against blacks, it says you shall make them equal. Okay, you shall make blacks equal to white. Shall make. That's why it's called affirmative. And how do you do that? Well, by giving them preferential treatment. When affirmative actions were instituted, the Lyndon Johnson said, well, Lyndon Johnson made this analogy. So there is this race for running. Okay. There is a running race, and one person has been exercising for past 100 years. The other person was in shackles. 묶여 있었다는 거죠. For past 100 years. Now you unshackle the person and you let the two people run. Is that a fair race? Right? That was the analogy that President Lyndon Johnson made. So to make it fair, you have to put the previously unshackled person in advanced position to make the race equal. So through affirmative action, I mean, it didn't require private parties. It didn't require private parties to give preferential treatment to blacks. If it did, it would have been, I think, unconstitutional. But what the federal government did was, federal government gives funding, right? Provides financial aid to a lot of things. And required affirmative or gave preferential treatment to those companies and agencies that instituted affirmative action. And some of the biggest recipients of federal funding are educational institutions. One of which is University of California at Davis. So to get the federal funding, they also instituted affirmative action. Actually, I mean, it's in California. I think they would have instituted affirmative action anyway, even without the federal funding. Here, this is how it worked. Every year, UC Davis Medical School admitted 100 students. But out of 100 seats, 16 were set aside for minority. So for 84 seats, everybody could compete, including blacks and whites. 84 seats were open to everybody, but 16 seats were open only to racial minority. So Becky was, in terms of just the numbers, just the test scores and GPAs, he was number 85th. So he filed a lawsuit saying that is discrimination, racial discrimination, because only because he was white, he could not get in. All right, this is racially explicit classification, right? If you are white, you can compete only for 84 seats. If you are black, you can compete for all 100 seats. Explicit discrimination. What level of scrutiny, what standard of review has to be applied to this, what some will call reverse discrimination? That's the question. What do you think should happen? What do you think should happen in a case like this? Well, if the explanation is more for, or the explanation about giving, the reason for examining some classification more strictly is historical purpose, how to come out on this one, on affirmative action. This is a discrimination supposed to benefit the people who are in the slavery, right? So maybe we should apply low-level review. But if you think level of scrutiny is trigger higher level of scrutiny because of the inherent unfairness of being discriminated for trait that you are born with, maybe we should apply higher level of review. And also, well, what about that? The fact that your parents or your grandfathers and their generations did something wrong against other people, why do you have to be responsible for? I mean, that's a typical argument raised by people like Becky. I didn't do anything wrong. Why should I be penalized for something I did not do? Well, think about that. what did the Supreme Court justices come out on this issue? So, 4 justices, Brennan, White, Marshall, Blackmun, said, okay, we have a dilemma whether we should apply rational basis review or strict scrutiny, so we'll just make a compromise. We'll just apply intermediate level of review. And under intermediate level, they would have uphold. Because of the significant risk, small letter paragraph on page 649, because of the significant risk that racial classifications established for ostensibly benign purposes can be misused, causing effects not unlike those created by invidious classifications, it is inappropriate to inquire only whether there is any conceivable basis that might sustain such a classification. Instead, to justify such a classification, an important and articulated purpose for its use must be shown. In addition, any statute must be stricken that stigmatizes any group or that singles out those least well represented in the political process to bear the brunt of a benign program. So for these reasons, they'll apply intermediate level of scrutiny, and they first decided on the level of scrutiny, and then they also agreed on the result after having applied that scrutiny. The result was that they all thought that the purpose of remedying prior discrimination was legitimate and sufficiently important to satisfy this test. So, remedying prior discrimination. Okay. Remedying prior discrimination. The fact that black people were discriminated in the past must have affected the educational merits of black children. So to remedy the effects of a previous discrimination, you have to give blacks preferential treatment. Now, that's 4 only out of 9. So their decision became a minority. Four conservative justices said, hey, this is just a violation of Civil Rights Act. You don't even have to go to constitutional law. Because discrimination is discrimination. But that was also only 4. So the casting vote was held by Justice Powell, who thought all racial classifications, whether beneficial for or discriminatory against the blacks, have to be subject to the same heightened level of review. And once that happens, what do you have to do? That to apply heightened level of scrutiny means you require a compelling governmental interest. You require something very important as justification for infringing on private interest. So in Korematsu, the case I talked about, national security or national security during war was one justification for such classification. So what is the compelling interest that will justify affirmative action here? Justice Paul said, the last paragraph, the fifth line from the top, okay, page 649, the last paragraph, fifth line from the top. Although the state had a legitimate and substantial interest in remedying prior discrimination, that interest did not justify the Davis program because there had been no prior judicial, administrative, or legislative findings of prior discrimination. So, what Justice Powell is saying is, hey, UC Davis did not really engage in any discrimination in the past. Yes, UC Davis Medical School admitted predominantly more white students than more black students. But that's not because of discrimination. It's just that more qualified applicants from the white group than non-white group. Yes, maybe it's because their parents lived more poorly than white parents. And maybe how well you do in school will be affected by how much financial support you get from your parents. But that's not the responsibility of UC Davis Medical School. So where is the prior discrimination that UC Davis, is trying to diffuse? So in terms of a very important governmental interest, prior discrimination, or remedying prior discrimination, as one. The other is, the court says, Justice Powell says, maintaining diverse student body. Diverse student body. How is that a compelling governmental interest? Justice Powell says these two are compelling government interests that could justify, so compelling enough to justify racial discrimination. Okay? But here, no evidence of prior discrimination. Here, okay, this is a good purpose, but what does Justice Powell say? Well, you have to do the least restrictive means. 침해 최소성 얘기하는 거죠. Least restrictive means. Here it was a quota. Okay. So once you are white, you are insulated from these 16 seats. That's too much. There must be a better way of giving preferential treatment. So says he would have permitted the last 4 lines on page 694. Instead, he would have permitted an admissions program under which race was deemed a plus in particular applicant file. Deemed a plus. 가산점 주라는 얘기죠. Very last line. An admissions program operated in this way is flexible enough to consider all pertinent elements of diversity in light of the particular qualifications of each applicant, and place them on the same footing for consideration, although not necessarily according them the same weight. What do you think about his decision? Why is diversity so important? Is diversity important enough to drop someone from school? To refuse admission to someone? What do you think? How important is maintaining diversity? Here I'm talking about racial diversity, right? I mean, from the white person's point of view, from Becky's point of view, okay, if these 16 seats are not given to racial minority, I mean, let's imagine an extreme situation where if these 16 seats were not given to racial minority, it will be all white medical school. And that's what UC Davis wants to avoid. But Becky says, what's wrong with all white medical school as long as they were picked on merits? They were selected according to merits. What's wrong with that? This is a state school. It's paid for by taxpayers. So for me, this is one of the few schools that I can get into. Other medical schools are too expensive for me. You ruined my dream of becoming a doctor. All for the goal of making a diverse student body. But diverse student body doesn't teach you medicine. Having diverse student body doesn't make you a better doctor. Any response?
Couldn't we go back to the tangible quality that was in prior cases? Although it has nothing that is direct to do with the medical education, education itself has public interest with the intangible qualities planted within it.
Yeah, but how does it help in terms of learning the medicine, right? I mean, intangible quality that the court talked about in intangible quality that the court talked about in Brown versus Board of Education was something else. The prestige of the school in the community, the prestige of the faculties. So, I mean, what the school was saying, hey, even if you learn from the same textbook, even if you hear the same thing, if you don't have that communication, if you don't have that in-person communication with renowned faculty members, and also with your colleagues, because there, it was just one student. They built a school just for one person, right? Why is it so important that you have a black classmate, right, for your study of medicine, right? So it is a very controversial topic, but not in the United States. It is very well accepted that diversity is a compelling governmental interest. I think the idea is that these doctors, these lawyers, they form the upper echelon of the society, and they make decisions that affect other people's lives. And if those decision makers are not diverse, then the decisions coming out of it cannot be fully democratic or substantively democratic. It will be formally democratic in a sense that probably they all have one vote, but it will not reflect the views of the racial minority. The decision-making group, will not benefit from the perspectives of the black participant in that decision-making group. That's why affirmative action exists only for professional schools and other more desired positions. Yeah, I mean, if you go out in the farms, most farm workers are Latinos. You don't have affirmative action for farm workers. You don't need to make farm workforce diverse, because they will not be making decisions. Okay, so anyway, I just wanted you to think about that. And page 650, we have fully love. Another affirmative action case. Here, according to the Federal Law, Public Works Employment Act of 1977, all state governments in building bridges and buildings had to give 10% of their contract money to minority business enterprises. 10%. Again, if your company's head is white, you can only compete for 90% of the construction money. If you are black, you can compete for 100%. I mean, not that you actually get 100%, I'm saying you can. %100% of contract money is open to you. What did the court decide? Number one, what level of scrutiny is applied in this case? Intermediate, rational based review, or strict scrutiny? Strict scrutiny, right? All justices say all justice said, so the third paragraph on page 650, the fourth line, the plurality noted that a program that employs racial or ethnic criteria, even in a remedial context, calls for close examination. Close examination. That means they are applying a heightened scrutiny. Also, Justice Power, in the paragraph right below, Justice Power repeated his view that racial classifications must be assessed under the most stringent level of review because immutable characteristics, I talked about immutable traits, right? Which bear no relation to individual merit or need are irrelevant to almost every governmental decision. Here he agreed with the plurality that the statute was justified as a remedy that serves the compelling governmental interest in eradicating the continuing effects of past discrimination identified by Congress. Okay. What has changed from Bakke case? Justice Powell thought this was remedying prior discrimination was important governmental interest, but he said he could not find evidence of past discrimination. But here he says he agreed with the plurality that the statute was justified as a remedy that serves the compelling governmental interest in eradicating the continuing effects of past discrimination identified by Congress. Continuing effects of past discrimination. Why? I mean, in Justice Powell's view, what's the difference between government contracting and education? Why does he think that blacks were penalized, or blacks' present position was penalized by discrimination decades ago in contracting, in construction business? But the same is not true for education. Can you think of a reason why? Continuing effects of past discrimination. How does discrimination done to your parents affect you? Or is it because construction business was more discriminatory than state schools? State schools didn't really have rules barring blacks. But in construction business, the contracts were given one by one, and maybe as they were being given, whites were given preference. And in Fully Love, again, Fully Love, although it was the affirmative action was approved as constitutional, there was no clear majority on what level of scrutiny should be applicable. Because if you read carefully, only still 3 justices I mean, if you track all the justices and what they say, you cannot really find a majority on that issue. And that issue was finally resolved in Crosson on page 652. It's a long case, I know. And here, what happened was, the city of Richmond did a similar program as in Fully Love, but it required 30% of contract money to go to minority business enterprises. The argument was that if you look at the second paragraph of the case, the plan was adopted by the Richmond City Council after a public hearing. 7 members of the public spoke to the merits of the ordinance. 5 were in opposition, 2 in favor. Proponents of the set-aside provision relied on a study which indicated that while the general population of Richmond was 50% black, only 0.67%, okay, less than 1%, 0.67% of the city's prime construction contracts had been awarded to minority businesses in the 5-year period from 1978 to 1983. Okay. And also on page 652, on page 653, the second paragraph from the top, there was no direct evidence of race discrimination on the part of the city in letting contracts or any evidence that the city's prime contractors had discriminated against the minority-owned subcontractors. Okay, what happened in this case? What does the Supreme Court say about a level of scrutiny? If you look at page 654, yes, strict scrutiny. The court says the paragraph, the second paragraph from the bottom, classifications based on race carry a danger of stigmatic harm unless they are strictly reserved for remedial settings. They may in fact promote notions of racial inferiority and lead to a politics of racial hostility. Okay. So giving preferential treatment to blacks will promote notions of racial inferiority. Yes, discriminating against blacks will promote notions of racial inferiority according to Brown versus Board of Education. But here the court is saying, doing the opposite way, preferring blacks will also promote notions of racial inferiority and will lead to politics of racial hostility. Or whites will hate blacks for being preferred. So hostility will follow. The standard of review under the Equal Protection Clause is not dependent on the race of those burdened or benefited by a particular classification. So you need strict scrutiny. Okay. And it answers Justice Marshall. Now, Justice Marshall is the person played by the lawyer you saw in Simple Justice. He later became the Supreme Court Justice. And he is arguing that the standard of review should be relaxed for discrimination benefiting minority. To that, what does the majority say? The second paragraph of page 655 says, how the dissent arrives, dissent is Justice Marshall, how the dissent arrives at the legal conclusion that a racial classification is designed to further remedial goals without first engaging in an examination of the factual basis for its enactment and the nexus between its scope and that factual basis, we are not told. Okay. What the majority is saying is, if you relax the standard, you'll never find out whether certain classification is remedial or not. Yes, you can easily find out whether it is beneficial for a certain group. But what the dissent, including Justice Marshall, is saying is that, hey, if certain discrimination, certain beneficial discrimination is to remedy past discrimination, then we have to relax the standard, we have to lower the standard. But the majority is saying, how are you going to find out whether it is remedial if you don't take a hard look at it? We have to take a close, we have to do a close examination even to find out whether this discrimination is just simply beneficial for minority or actually remedial. And then the court, so for instance, the court talks about how blacks comprise approximately 50% of the population of the city of Richmond. Okay. Now, 5 of the 9 seats of the city council are held by blacks. Are they minority or majority in passing this preferential treatment of the city? They are the majority. So now if we apply relaxed review, if you apply low-level review, you are not supposed to look at these things, right? I mean, that's the majority's argument. I mean, I don't completely agree with it, but that is the majority's argument. And then they engage in strict scrutiny. In subsection B, starting page 655, what does the court say? Well, they say something similar to what Justice Powell said in Bakke, right? It says, the second, page 655, second paragraph from the bottom, a generalized assertion that there has been past discrimination in an entire industry provides no guidance for a legislative body to determine the precise scope of the injury it seeks to remedy. It has no logical stopping point. Relief for such an ill-defined wrong could extend until the percentage of public contracts awarded to minority business enterprises in Richmond mirror the percentage of minorities in the population as a whole. Now, the fact that only 0.67% of the contract money go to blacks. How do you know whether that is because of discrimination? Maybe it's because white people are better builders. You cannot just jump to conclusion. Now, that is, without any other scientific analysis, the majority is correct. The numerical difference itself is not evidence of discrimination. So, when the majority says, hey, there is no logical stopping point, what they mean is, so if a numerical difference is the sign of discrimination, then when is past discrimination fully remedied? Until 50% of contract money go to blacks? So if only 30% go to blacks, then still discrimination? 90% of professional basketball players are blacks. So does that mean that whites are discriminated? "90% of college professors are whites." Doesn't mean that there is a discrimination against the black faculty members. So, because there is no direct evidence of discrimination, of course there is no compelling governmental interest in remedying that. Well, that is the majority's argument. What is the city saying? How is the city justifying its affirmative action as remedial, or remedial of the past discrimination? If you look at the very last paragraph of page 655, the sixth line from the bottom, the city cites the exclusion of blacks from skilled construction trade unions and training programs. This past discrimination has prevented them from following the traditional path from labor to entrepreneur. The city also lists a host of non-racial factors which would seem to face a member of any racial group attempting to establish a new business enterprise, such as deficiencies in working capital. So blacks will usually have less money, right? Inability to meet bonding requirements. Bonding, 그러니까 채권을 사고 문제가 발생하면은 대신 책임을 져줄 그런 거 사는 거 이제 bonding requirement라고 하는데, to get a bond, you need to have good credit, and blacks usually have not as good credit as white people. Unfamiliarity with bidding procedures, well, because not many blacks actually have done the bidding, and if you are to learn bidding from your friends are more likely to of the same race. So not much knowledge. And disability caused by inadequate track record. Or, this is like catch-22, right? when you look for a job, they look for experience, but to get that experience, you need a job. What does the majority say about this? While there is no doubt that the sorry history of both private and public discrimination in this country has contributed to the lack of opportunities for black entrepreneurs, this observation cannot justify a rigid racial quota in the awarding of public contracts in Richmond, Virginia. Like the claim that discrimination in primary and secondary schooling justifies a rigid racial preference in medical school admissions, what they are talking about here. Talking about Becky. Okay. An amorphous claim there has been past discrimination in a particular industry cannot justify the use of unyielding racial quota. So it's not clear. So the majority is the majority saying there is no past discrimination, or saying there is no past discrimination that justifies this strict racial quota? Which of the two? First, second? Second statement, right? I think that is enough on that. If you look at page 658, how does the majority distinguish fully love from Becky? I mean, one is a federal affirmative action, one is a city affirmative action. One reserves 10% for MBs, one reserves for 30%. Is it all the difference there is? I mean, this is a common law court, so it has to justify its new decision with respect to the previous decision. So it has to distinguish. It has to give a reason why this case is different from Becky. I mean, fully love. What reason does the majority give? Okay.
So the decision makers were also, the majority were black, so it was different.
Okay. I think that goes to the level of scrutiny. All right. If it was if discrimination was legislated by a white majority legislature, okay, then it will be more suspicious. The court will be more suspicious, and therefore will apply heightened review. But here, assuming both fully love and Crossan were decided on strict scrutiny, what's the difference?
Well, in this action, other minorities and blacks were included. There were like Indians, Eskimos, or other. So they questioned the motive of inclusion.
Okay.
It's not to any past discrimination.
Okay. All right. And also, if you look at page 659, unlike the program upheld in Fully Loved, the Richmond Plan's waiver system focuses solely on the availability of MBEs. There is no inquiry into whether or not the particular MBE seeking a racial preference has suffered from the effects of past discrimination by the city or prime contractors. Given the existence of an individualized procedure, the city's own interest in maintaining a quota system rather than investigating the need for remedial action in particular cases would seem to be simple administrative convenience. So, there is a more individual considerations given in Fully Love than in this case. Also, 30%, I think, is considered too big. If you look at 658, the second paragraph from the bottom, the 30% quota cannot be said to be narrowly tailored to any goal except perhaps outright racial balancing. It rests upon the completely unrealistic assumption that minorities will choose a particular trade in lockstep proportion to their representation in the local population. Okay. What does the dissent say? Dissent is page 663. Page 665. At the top, it says, Richmond has two powerful interests in setting aside a portion of public contracting funds for minority-owned enterprises. The first is the city's interest in eradicating the effects of past racial discrimination. But Richmond also has a second compelling interest in setting aside that interest is the prospective one of preventing the city's own spending decisions from reinforcing and perpetuating the exclusionary effects of past discrimination. So the minority wants to add a third the third compelling governmental interest, other than diversity and other than remedying past discrimination, which is preventing perpetuation of past discrimination. When government channels all its contracting funds to a white-dominated community, the underlined part, when government channels all its contracting funds to a white-dominated community of established contractors whose racial homogeneity is the product of private discrimination, it does more than place its imprimatur, 도장이죠, 도장, approval, on the practice which forced and which continue to define that community. It also provides a measurable boost to those economic entities that have thrived within it, while denying important economic benefits to those entities which, but for prior discrimination, might well be better qualified to receive valuable government contracts. So, the minority is saying it's not just remedying past discrimination, but it is also preventing future discrimination that requires affirmative action. So that sounds more like diversity argument. So if you look at page 666, the second paragraph, the bottom, the roughly equal numbers of minorities and non-minorities enrichment. Yet minority-owned businesses receive 1/75 the public contracting funds that other businesses receive. So the minority is saying, yes, numerical disparity does not in itself shows that there has been discrimination. But if you continue giving contract money in the same rate, 0.67% to black, that is just too much. So, if you go to the underlined part on the same page, the minority also talks about how not giving more money to blacks now will in the future handicap blacks even more. Okay. So If you think about it, this is more in the sense of keeping a diverse business community in government contracting. And then and then the minority talks about whether the strict scrutiny should be applied. You know, that goes from page 668, 669, 671. Let's just look at just one part out of that. So 669, the bottom paragraph, the court is saying, the majority said, you know, strict scrutiny is appropriate, especially because Richmond Council was black majority. Okay, and the minority says in response, what does the minority say? If you look at the fourth paragraph from the top, page 670, Richmond's own recent political history underscores the facile nature of the majority's assumption that elected officials' voting decisions are based on the color of their skins. In recent years, white and black council members in Richmond have increasingly joined hands on controversial matters. When the Richmond City Council elected a black man mayor in 1982, his victory was won with the support of the City Council's 4 white members. The vote on the set-aside plan a year later also was not purely along racial lines. Of the 4 white council members, 1 voted for the measure and another abstained. The majority's view that remedial measures undertaken by municipalities with the black leadership must face a stiffer test of Equal Protection Clause scrutiny than remedial measures undertaken by municipalities with white leadership implies a lack of political maturity on the part of the nation's elected minority officials. So there are these pockets. There are these pockets of local government where minority may be in the leadership, but those are just pockets. And they have made efforts to give minority leadership, create minority leadership as much as possible. And it's very welcomed. Putting Obama in the presidency was welcomed by the whole nation. But now that Obama is president, now it is under black leadership. Anything benefiting blacks now has to be considered suspect and has to be subject to higher level of review. That is just not fair. That takes out of a historical context. That makes the historical context of political affirmative action irrelevant. So that is a cross-on case. Now you can see the a lot of dispute on the level of scrutiny and different arguments and values that are at work in equal protection arena. Let's move on to page 714, Michael M. versus Sonoma County Superior Court, and we'll talk about gender discrimination. So here, so man, woman, boy, girl, and Now, do we know whether this is the majority applied heightened review or rational basis review? I mean, it's not clearly stated, but just reading the case, what level of review do you think they are applying? Are they just saying, oh, you know, if the state had a legitimate interest in protecting something, I don't know what they are protecting, but if they are, protecting woman's sexual integrity, if that's what the law is, then doesn't matter whether it is discriminatory against some people or not, like method and users. Is that the kind of the feel of the case, or is the court engaging in some more substantial review? Yes. Right. So the court talks about the court actually evaluates. I mean, in rational basis review, the court does not engage in substantive evaluation of the state's reasoning, but here the court does engage in that. So what is that strong interest? What is the strong interest that justifies this law?
Prevention of illegitimate pregnancy, which causes profound physical, emotional, and psychological consequences of young women.
Okay. All right. So, preventing, I mean, there is no such thing as illegitimate pregnancy. So this case from 1980s. So many politically incorrect expressions, but basically, teenage pregnancy, without, I mean, in their standard, any pregnancy outside the marriage will be considered illegitimate. So I think better term is teenage pregnancy. So the goal is to prevent teenage pregnancy. But if really goal is to prevent teenage pregnancy, why not punish both? Why do you punish just one? What is the majority's answer to that? Okay, so more risk to women than to girls than to boys. But does it justify making it does it really justify making one a criminal? If the real goal is to prevent teenage pregnancy, well, the fact that the girl suffers some consequences doesn't mean that if having sex is made criminal, strike that. If having sex is made criminal, women girls will also try not to do it, right? If you just make it criminal just on boys, what's going to happen? Girls will have no deterrence in having sex with the boys. They'll go out, seek sex with the boys without any consequences. The majority is saying, there is more risk to girls, which will act as a natural deterrent. So you don't need a legal deterrent. Okay. But is that really important enough? Is it really important enough to punish just a boy when boy and girl had the consensual sex?
It says here also that the court thinks that the gender-neutral statute would be ineffective because females are unlikely to report violations of the statute. She herself would be subject to criminal prosecution.
Yep, that's another thing that majority talks about, that if it's made criminal on both sides, then then it's hard to detect when teenage sex happens. So we want to reduce teenage sex, and girls, somebody should feel free in reporting so that the system can detect when sex happens. What does the dissenter say? Again, you can see Justice Marshall in there. the minority is saying, okay, detecting teenage sex and equalizing deterrence. Is that, well, so there are two things that majority say, right? That women will not seek sex as actively as, girls will not seek sex as actively as boys. So, you don't need to set a deterrent. You don't need to set up a legal deterrent against girls. That's one thing. The other thing is, making detection easier by allowing girls to report the crime. Well, let's take one at a time. Detecting crime. Is that really a justification strong enough to discriminate people by gender? So just because you are a man, you just had consensual sex. And just because you are a man, you go to jail and the other does not. I mean, if enforcement is, or detecting crime is such an important goal, maybe the court should, the state should hire more police force. It's like accepting, administrative convenience cannot justify discrimination like that. If it's about giving jobs, like in Beezer, maybe, and finding good transit authority employees, and also, leaving out methadone users, penalizing methadone users for having fallen into drug addiction in the past, that's not as unfair as treating somebody different because of a sex. But here, it is something you are born with. Just because what you are born with, someone goes to jail, someone goes to prison, and someone does not. It's like saying, we don't get that many good black applicants, so we're not gonna review black applications. We'll just look at white applications because we want to reduce money spent on reviewing applications. Hey, if you want to reducing resources spent in detecting crime, right? Can that be justification for sending partners in a criminal activity, only male partners in criminal activity into prison and female partners not? Okay, that's one argument. How about the natural deterrent? Natural deterrent argument. Sure. It has not been proved that making it criminal on both sides, right? Making it criminal on both sides will be more effective. I mean, will not be effective. It has not been proved that it will not be more effective. Okay? So, we are in the heightened review. I mean, we don't know whether it's a strict scrutiny or intermediate scrutiny, but under heightened review, if it's more effective, and if it's more effective and less discriminatory, the state has to prove why it's not taking that more effective and less discriminatory measure. Right? If a racially neutral statute is more effective in preventing teenage pregnancy, that is less discriminatory and is more effective, it's unconstitutional not to take that action. Also, if you look at the bottom paragraph, until very recently, no California court or commentator had suggested the purpose of California's statutory rape law, this law, was to protect a young woman from risk of pregnancy. Indeed, the historical development of the statute demonstrates that the law was initially enacted on the premise that young women were to deemed legally incapable of consenting to an act of sexual intercourse. Because their chastity was considered particularly precious, young women were felt to be uniquely in need of the state's protection. In contrast, young men were assumed to be capable of making such decisions for themselves. The law, therefore, did not offer them any special protection. Look at the footnote 4. In a remarkable display of sexual stereotyping, the California Supreme Court stated, so this is California Supreme Court long time ago. The legislature is well within its power in imposing criminal sanctions against males alone because they are the only persons who may physiologically cause the result which the law properly seeks to avoid. Footnote 4 on page 717. So, in the California Supreme Court said things like, sex is what man does to woman. It's not something man and woman do together. It is what men do to woman. So this idea that deterrent, the idea that there is a natural deterrent for women translates into this presumption that women are less interested in sex, and that women, even if they want to have sex, their decisions are not well informed. Therefore, just like minimum wage law, where employees receiving sub-minimum wage, they don't get punished. Only the employers giving sub-minimum wage, they get punished. Okay? So, just like sex is what man does to woman, wage is something that employers give to employees. Therefore, to protect the employees receiving sub-minimum wages, you punish only the employers. Well, we can say the same thing about sex. to protect girls from engaging in sex that they probably didn't want to do, or the law presumes that they didn't want to do, you criminalize only the man. So the minority is saying this is based on sexual stereotype. This is based on assumption that girls are passive participants in sex. Now, what the minority is saying, well, I mean, what you should remember is that it may be true that women are less active participants in sex. But can you make a law based upon that assumption? Especially criminal law. Yes, if you do, if you take an average academic aptitude test, yes, blacks will probably do less, will do worse than whites on average, but can you make law according to that comparison? Can you accept just white applications as opposed to, exclude all black applicants just because it's statistically proven that white groups have greater average? Just because women are presumed to be inactive, passive participants in sex, can you criminalize the consensual sex and punish just the man? That is the argument. Okay, we are past the time limit, so if you have questions, please ask me in the next class. We'll go into freedom of speech next week for sure. Okay.